Greetings, legal minds, and for the purpose of this tutorial session, I will be briefly analyzing the general position of the law in relation to the enforcement of the fundamental objectives and directive principles of state policy in the Nigerian Constitution. It is important to note that we have two categories of rights in Nigeria. In the Nigerian human rights law, two different kinds of rights are recognized. In light of the provisions of the Nigerian Constitution, we have what is known as the civil and political rights, which are all enshrined in the provisions of Chapter 4 of the Nigerian Constitution, which are termed to be the fundamental human rights. Secondly, we have some specific group of rights which are known as the social, economical, cultural, and development rights, which are established in Chapter 2 of the Nigerian Constitution, legally seen as the fundamental objectives and directive principles of state policy. So already know the general principle is such that according to the provisions of Section 46 of the Nigerian Constitution and also Section 1 of the Fundamental Rights Enforcement Procedure Rules 2009, everyone whose right is likely to be breached, whose right has been breached, and whose right is being breached has the right to seek redress in the Federal or State High Court, and you will be entitled to some specific remedies. This only applies to the provisions of Chapter 4 of the Nigerian Constitution. But according to the provisions of Section 6, subsection 6C of the Nigerian Constitution, you would find something intriguing in the sense that that provision actually ousts the jurisdiction of the courts in hearing matters involving the enforcement of the rights provided for in Chapter 2 of the Nigerian Constitution. Let me explain. Why the provisions of Chapter 4 of the Nigerian Constitution are generally enforceable, you can seek redress for the breach of this right. The provisions of Chapter 2 of the Nigerian Constitution, the social, economical, cultural, and development rights, are generally not enforceable. This means that when there is a breach of any of these rights, which is mostly done by the Nigerian government, you cannot, according to the provisions of the Nigerian Constitution, institute an action against the government for the breach of those rights seeking redress. This is because the provisions of Section 6, subsection 6C of the Nigerian Constitution already prevent the courts from hearing matters involving the breach of the rights. However, there is an exception to this because a close examination of the provision of Part 1, Second Schedule of the Nigerian Constitution would identify the list of the certain things that the legislature have been given power to make laws on. That is the exclusive list, the concurrent list, and the residual list, which is implied. The exclusive list in item 60 sub A says that the federal legislature, that is the National Assembly, has the power to make laws with respect to the direct observance and enforcement of the rights provided for in Chapter 2 of the Nigerian Constitution. That means that whilst we generally understand that the provisions in that particular section of the Constitution, from Section 13 to Section 24 in Chapter 2, is generally not enforceable as established in Section 6, subsection 6C, the Constitution gives the federal legislature, the National Assembly, to make laws, to enact laws that would see for the observance and enforcement of these different rights. So the only circumstance where these different rights can be enforced is when the legislature has made some specific enactments that sees to the effective enforcement of those rights. Just like the international laws, international treaties and covenants are not enforceable in Nigeria unless it has been ratified by the legislature in Section 12 subsection 1. That is the same position in the enforcement of Chapter 2 of the Nigerian Constitution, such that unless the legislature makes enactments that gives effect to the observance and enforcement of that right, the fundamental objectives and directive principles of state policy, it cannot be enforced, and you cannot institute any action against the state government or the federal government for the breach of this right. Upon a close examination of that section, you will see some specific rights like the right to adequate healthcare facilities, the right to free education, minimum education standard, and some other specific rights that pertains to the economy, that pertains to the social activity of every individual in the state, that pertains to the development of a particular state, and that pertains to the promotion of the cultures in Nigeria. When there is a breach of these rights, you cannot, just like you can in the provisions of Chapter 4 of the Constitution, institute an action against the state or federal government for the breach and enforcement of these rights unless the legislature has made some specific laws that gives effect to that. And when you're instituting an action, the basis for your action would now be those enactments that have been made by the legislative arm of the Nigerian government. This is well settled position of the law. Do well to follow us so that you will get tired from learning the law every day.